Now let's discuss Section 29. Section 29 basically just tells you that one notice is enough to register more than one security agreement, which means that one notice is also enough to register more than one security interests. So that's Section 29. Section 30. A notice shall be effective at the time it is discoverable on the records of the registry. So, from the time na pwede nang makita yung notice sa registry, it is already effective. And what does that mean? It is already binding as against third persons. We've already discussed that last week, no? So another thing that you can see here in Section 30 is the fact that the notice shall be effective for the duration of the term indicated in the notice. This is consistent with what we've discussed kanina, that aside dun sa 1 to 5 na sinulat no, sa Section 28 that must be contained in the initial notice, kailangan rin according to Rule 5, Section 5.5 of the IRR of PPSA na nakasulat ang duration ng notice, no? So, it's consistent with our discussion. And finally, a notice substantially complying with the requirements of this chapter shall be effective unless it is seriously misleading. So diretso na tayo sa Section 31. We discuss what is a seriously misleading notice. A seriously misleading notice is one that does not provide for the identification number of the grantor. So again, we go back to our discussion. Ang identification number pertains to the grantor and not to anyone else like the secured creditor. Kung walang ID ang grantor, then that's a seriously misleading notice. Now, let's go to Section 32, Amendment of Notice. If sa Section 28, we were discussing about what an initial notice must contain, Section 32 provides for naman what an amendment notice must actually provide for. So, a notice may be amended by the registration of an amendment notice that, number 1, identifies the initial notice by its registration number, and number 2, provides the new information. Yun lang yung dalawang yun lang ang kailangan talaga substantially for an amendment notice to be acceptable. Identification of the initial notice by registration number and the new information. So an amendment notice that adds a collateral that is not proceeds must be authorized by the grantor in writing. Also, an amendment notice that adds a grantor must be authorized by the added grantor in writing. In short, kung may i-add na collateral or may i-add na grantor, no, there should be an authorization in relation to that. Next, an amendment notice shall be effective only as to each secured creditor who authorizes it. And finally, it should be effective only from the date of its registration. So that's Section 32 as compared to, again, the requirements as provided for in Section 28. Section 28, initial notice. Section 32, amendment notice. Now, let's go to Section 33, continuation of notice. The period of effectiveness of a notice may be continued by registering an amendment notice, again identifying the initial notice by its registration number. So, whenever we're talking about an amendment notice, usually ang number 1 na kailangan would be the identification number, the registration number of the initial notice. And next, a continuation of notice may be registered only within 6 months before the expiration of the effective period of the notice. So, kanina we discussed that aside dun sa 1 to 5 sa Section 28, we need to provide for the duration of the notice as provided for in Rule 5, Section 5.5 of the IRR. So, kailan mo actually dapat i-register yung continuation of notice? You should register it 6 months before mag-expire yung effective period ng notice mo as provided for in your initial notice. So that's what you get in Section 33. Now, Section 34. So, Section 34 talks about a termination notice. So we talked already about an initial notice in Section 28, an amendment notice in Section 32. Now in Section 34, ano dapat ang nakasulat sa isang termination notice? Termination notice must identify, again, the initial notice by its registration number. And this is a requirement similar to the amendment notice. No? And number 2, it should identify each secured creditor who authorizes the registration of the termination notice. So if you would notice, ang important when it comes to a termination notice is yung authorization ni secured creditor. You would ask why? Because the secured creditor maapektuhan yung right niya, no, over the security interest by virtue of the termination. Hence, kailangan ng authorization niya sa isang termination notice. So, recap lang so far sa ating na-discuss. When we talk about an initial notice, you go to section 28. When we talk about an amendment notice, you go to section 32. And when you talk about a termination notice, you go to section 34.